Hi, I'm Gary Tabakman. I'm a criminal defense lawyer in Houston. Today I'm going to talk to you about federal sentencing, specifically the federal sentencing guidelines and the 3553A factors that you need to consider in order to help you get the best result possible in a federal sentencing. Prior to 2005, in the seminal case of United States v. Booker, courts were required to consider mandatory sentencing guidelines. That case has fundamentally changed the way that federal judges sentence individuals to time in prison, and those sentencing guidelines are now advisory. The guideline manual, which we have here, specifically talks to judges and gives them recommended guideline ranges for purposes of considering what a just punishment should be. Today I'm going to talk to you specifically about the 3553A factors, which is in 18 U.S.C. 3553A, which is the United States Code. That provision specifically breaks down 7 factors that a judge should consider when giving an evaluation to your specific circumstances in order to decide what an appropriate range of punishment should be and how to punish you as an individual based on the crime that you have committed, either through a plea deal or post-trial. Now, those factors are as follows. Number 1, we have nature and circumstances of the offense, history and characteristics of the defendant, the sentencing purpose, U.S. sentencing guideline considerations, policy statements, avoiding unwarranted disparities, and restitution. So starting from the top, the nature and circumstances of the offense specifically discuss the seriousness and harm of an offense. You may fall into a case, oftentimes in a conspiracy case, that could be very complicated based on the dynamics of the case and how it was developed, the amount of individuals involved, the specificity of the offense and the harshness of what had occurred. So as an example, in federal court, we have many different types of cases, and obviously all of them are very serious because most of them have a range of prison time. Some of these cases involve human trafficking, drug trafficking, and other offenses that may result in death or serious bodily injury to somebody. Other cases may involve financial fraud crimes and crimes that revolve around Medicare fraud, Medicaid fraud, FCPA violations, so on and so forth. These 2 types of cases obviously range in different types of serious considerations of how it impacted or whom it may have affected. A judge is supposed to consider your individual involvement in every single one of those circumstances in order to come to a decision that will ultimately give you the right consideration for why you stand out differently versus everybody else in a particular case. Your lawyer should be able to highlight your individual involvement in such a way that separates you out from everybody else. So this is an essential factor that your lawyer should be very well versed in order to get you to the right place and help you advocate and give you a voice before the court that a court may not have otherwise known or had a way to consider your individual involvement. Number 2 is history and characteristics of the defendant. Obviously, in my opinion, this is probably where you can gain the most traction in order to get the court to really consider and listen to who you are as an individual. We all come from different walks of life and different backgrounds. You may have been born to a family circumstance of where you never truly really stood a chance. You may have born in a situation to a family where you've had only a single parent, you grew up fairly poor, and the likelihood of you ending up in a situation where you may have ended up committing a crime or multiple crimes and led you onto a pathway of certain challenges and certain things that you have done that you may have wanted to do differently was almost, the probability was very high basically. And we want to be able to highlight that to the court in order to explain what had happened to your past, your background, how it developed, and ultimately how you found yourself here before the court and before the judge that's considering your sentence. Understanding the dynamics of that is super important. I think where a lot of lawyers go wrong and where they don't really focus enough on the individual characteristics happens to be with age and happens to be with an individual's background. It could be ethnic background or it could be socioeconomic background. There are many different circumstances, obviously, as we're all very different. I have utilized many strategies within this space in order to be able to express the individual characteristics to a court that will get the court to make an honest evaluation and an appropriate one that could help advocate for a client that truly feels like they are not being heard. Oftentimes, this is very effective by using expert witnesses. It could be psychiatrists or psychologists that can come in order to break down the barriers that an individual may have had and background circumstances that individual may be going through that a court should be considering in order to highlight the fact that what happened with them in the past is not necessarily indicative of what may happen with them in the future. So this is a advocating part of talking about recidivism, and your characteristics and background can make a really huge difference for purposes of the court in considering a sentence. Within that space, we also have the support that you may have in the community. So when we talk about support, we talk about character letters, individuals that can come in and advocate on your behalf that know you best, such as family members, friends, neighbors, workers, co-workers, your employers, people that you have spent the most amount of time around that can talk about who you really are as an individual versus a cause number. Because right now, the way that it sits and a judge is looking at your case, all they see is a cause number. They don't necessarily see a person before them. And we want to humanize you. And so that is a really important part of the second factor. The third is the sentencing purpose. So we have punishment, deterrence, public protection, rehabilitation. Obviously, the reasoning behind a sentencing is punishment. But when we talk about punishment, we have to talk about what's reasonable and what's not reasonable. And the difficult part about that is explaining to someone why we believe a particular sentence is appropriate or not appropriate for this particular individual. And for what you may be going through is very different from what another individual within that same case is going through. And so rehabilitative processes and the aspect of deterrence is certainly an important factor that the court has to consider. And so this is where we come into a space where we discuss your chances of potentially recommitting the offense, which is what's called recidivism, what we can do in order to avoid that. How can we assure the court and provide certain protections for you that can help get you into a space where you can ultimately provide more of a shining light to the court that gives the court the ability to have confidence in the fact that you're able to overcome the current circumstances and ultimately come out on the other side of a prison sentence that lets the court know that you're unlikely to find yourself back before the court. That, again, is an advocating part that goes hand in hand with the characteristics of a defendant or a client. And I think your lawyer needs to be able to effectively advocate on your behalf to do this in the most proper way. And obviously, there's more to be said with respect to that because every single judge is different, and we could talk more about that in just a minute. The fourth thing that needs to be considered is the sentencing guidelines and the advisory range within this guideline manual. So this is a complicated part of sentencing. I think a lot of lawyers don't effectively communicate about this portion, which is the sentencing guideline manual right here and the specific chart that places you into a specific category that is being recommended to the court. Now, there are ways to address the chart, and there are ways to address the advisory guideline range. There's a whole slew of legal strategies that are used in order to be able to get the court outside of that range. Specifically for us, what we try to do is obviously go below that range. So oftentimes what we talk about here is what's called variances and departures. And what we want to be able to do is highlight to the court either through the notations that are made within a particular guideline or through statutory authority that's been created or prior case law in your specific type of case that has been addressed before, whether it's in this circuit or in another circuit or through the Supreme Court, that could help highlight that your case is appropriate to go outside of the advisory guideline range. For me, this is a really large portion of my federal practice. I think that I file objections in almost 90+% of cases that I have. And this is where you can get the most creative traction in order to be able to highlight certain aspects of how the advisory guideline range is not fair to your particular circumstances or to your case or the involvement that you had in your case, such as where you fall on the hierarchy of individuals and who did what, when, and how. Fifth is policy statements, which is the Sentencing Commission guidance. So the Sentencing Commission is the commission that sits in Washington that puts together this advisory guideline range and specifically talks about what should go into the guideline manual and how we should change the guideline manual, address the guideline manual, add or take away from the guideline manual. These policy statements oftentimes are important because when you read the guideline manual, it's hard to understand what specifically was the commission thinking in adding or taking something out of the manual. Once you get into the nuts and bolts of that entire process and what the commission does in order to come to that conclusion, it gives you an ability to formulate an argument from the perspective of what the commission was trying to express to the courts. Oftentimes, this is a very overlooked part of a federal practice, and it's important that we understand how to look for those specific things, and when you find those specific things, how to advocate your client's position through the commission's eyes. So I highly suggest that you hire an attorney or communicate and consult with an attorney that understands that part of the 3553A factors, because again, this is another portion of advocating on your behalf to get you a much better outcome through a federal sentence. The sixth is avoiding unwarranted disparities. There is a lot of traction that can be made in this space if done appropriately. What I mean by done appropriately is we oftentimes look at sentencing disparities just simply within your case or a case that is pending. So if you take a look at the case, and just as an example, if it's a conspiracy case, let's say that there's 5 to 10 individuals with that conspiracy case, lawyers oftentimes just simply focus, well, who did what, when, and how in that particular case. What I do, and my recommendation is, you pull up as many cases as possible of similar nature throughout the entire country. Look at how federal judges in other jurisdictions are addressing these types of cases, or look at how federal judges in other jurisdictions are addressing cases similar to you as an individual, right? So I could take, for example, a case where somebody may have been charged with material support of a terrorism organization, which is usually one individual charged in a case. If I take that type of case, I want to be able to look across the entire country to find every single one of those cases to see how judges came to the conclusion of what an appropriate sentencing guideline range would be, or what an appropriate sentence would be at the conclusion of that case. If done right, you can help formulate an argument and put together an advocating point of view that highlights that your jurisdiction, our jurisdiction, wherever your case may be, is not taking into consideration how other federal judges are addressing that particular issue. So again, talk to an attorney that understands this part and can get creative with advocating on your behalf or on your client's behalf. Seventh is restitution. Obviously, restitution is usually as a financial advantage. Some clients may have the ability to pay more money than others. I think that restitution could go one of two ways. This is, again, an advocating part that could be made for a client that doesn't have the financial means. So, and what I mean by that is, just as an example, if you have that is not financially secure, that committed a financial crime, as we've seen in a lot of PPP fraud cases, which is the payment protection plan fraud cases that came out since the COVID pandemic, many of these individuals committed offenses created in massive losses for purposes of taxpayer dollars. However, a lot of them, they don't have the capability or the money to pay money back. You have individuals on the other spectrum that have committed the same crime but can pay the money back. And so the easy argument to make is, well, this person can pay the money back, so they should receive a more lenient punishment. But it's not fair to the individuals that actually can't pay that money back. So the creative argument here, of course, is that we have to find a balance and a balancing act to say that, well, just because this person cannot pay the money back doesn't mean that they should receive a more harsher sentence than the individual that can pay the money back. And so part of that scope is, again, looking at unwarranted sentencing disparities, which is how a lot of these 3553 factors, they can kind of interplay with one another. If you take a look across the board, for example, at all of these types of cases all over the country, and you take a look at, well, individuals that were able to pay the money back received much more lenient sentencings, I would argue that that is not a fair assessment of your individual circumstance and for you as an individual if you weren't able to pay that money back right away. So again, all of these factors coming together help a judge determine what the appropriate sentence for you may be. I think the one most important thing that I want to consider before I let you go is federal judges are human beings, but they're also lonely human beings. And this is not a way to look at federal judges differently, but it's a way to understand that it's a very difficult job and it's a lonely job because they are the only ones that will ultimately make the decision in your case. We want to be able to consider that, and you have to know the court that you're going before and understand that judge and how that judge addresses certain types of cases and how that judge will ultimately decide what the appropriate punishment for you may be. You need to talk to a lawyer that understands all of these concepts and understands the court system and understands these specific judges that may be considering your future. Call me for a free consultation. I'd be more than happy to break down any and all factors with respect to federal sentencing, specifically the 3553 factors that we just talked about. If you want to get to know me better, click on the link above for a question and answer video that gives you a little bit more understanding of who I am and how I can help advocate for you. Thank you.